Welcome in our expert analysis of the Murdaugh trial today. So much to cover, Billie Jean, starting with a big announcement from Judge Newman. Before we get to that in just a moment, I want to introduce, for those who haven't had the pleasure of hearing his expert analysis yet, trial attorney Carl B. Grant. Carl, almost every day, some stunning development. Today, it was regarding jurors in this case. Let's listen to the announcement that Judge Newman made first thing this morning.
With two jurors who have tested positive for COVID, and they will not be able to continue. They've confirmed the positive tests by sending them to the clerk of court, who has forwarded copies to me. And I've spoken with each of those jurors, and they are one is symptomatic, and one had a cough and sore throat, and they've both been relieved, so we have two alternates.
So, Carl, so many questions about how this could impact the trial. Heard some testimony, not testimony, but conversation between the attorneys in the courtroom today saying, should we possibly postpone? But what happens if they do run out of jurors? I mean, it won't be a surprise if another juror tests positive.
It won't be a surprise. In fact, additional testing is going to be done Wednesday. And if they run out of jurors, in other words, if you get less than 6, which is what they have as far as alternates, now they're down to 3. Because it's my understanding they started out with 6. If you get less than 12, the judge is going to have to declare mistrial. And that's just going to be so unfortunate for everybody.
Yeah,
wow.
So what happens if a mistrial is declared? How does that play on the defense? Would they try Alec Murdaugh again?
Oh, absolutely. Jeopardy does not attach until the jury is sworn, and there's an ultimate decision really on the facts and the law as to what the case is. In other words, if a person made a motion for a directed verdict and the judge granted that, in other words, declared that the man is not guilty as a matter of the law simply, the evidence simply failing completely, then that's the end of the case. Or if in fact he goes to verdict and the jury finds him not guilty, of course, jeopardy has completely attached because he's been found not guilty. They couldn't try him again. But absent that, just because a mistrial has been declared, that does not prohibit the prosecution from trying him again. It's the same analysis if there's a hung jury.
Wow. And even as the attorneys floated the idea of possibly postponing the trial to see if anyone else tests positive and to make sure everybody's going to be healthy, and Judge Newman basically said, look, we're moving on. There could be a lot of things that take people out of play. The longer you drag this out, the more of a risk that becomes.
That's a very true point. And that's absolutely true. The longer you ask your questions that may seem to be unimportant, the longer your examinations go, as the judge used the word attrition kicks in. And that's an absolute fact.
There was a lot of testimony today about DNA evidence, including blood found on different belongings of Alec Murdaugh. There was blood found on the steering wheel, tested on his shorts. What do you think was the most piece of compelling evidence that was released today in court?
I think the evidence of the DNA on the steering wheel, okay? I think that's very strong, and I think there's other evidence that's still coming out, of course, and things that have already been testified about, but I think that's one of the strongest things I heard today, the DNA evidence on the steering wheel of his vehicle that had his DNA and Maggie's DNA.
And Carl, still rampant speculation about whether Alec Murdaugh will take the stand. We did hear today that the prosecution is expected to rest its case sometime this week. If they decide to put Alec on the stand, first of all, your assessment. I mean, we know that that's a risky move, but there are a lot of issues and questions in this case they can't explain without putting him on the stand. So what's your inclination as far as which way you think they might be leaning?
It's a risk-benefit analysis. Again, the defendant has the right to testify if he wants to, again, as long as he's going to testify truthfully. But here's the way the defense attorney normally analyzes this. Has the client's story already been told? And it has. In fact, when the prosecution decided to offer his videotape statement into evidence, that was a gift, as far as I'm concerned, to the defendant and his lawyers. Why? Because it gets the defendant, gives an opportunity to tell the story without getting on the witness stand. And through teary eyes, if you look at his videotape statement, he said, what? I did not do it. What better to use than that statement without risking him to get on the witness stand? Now, there must be something very important that they're going to need for him to say that has not already been said for him to get on that witness stand.
Yeah, especially when you consider the forensic pathologist. She's on the stand right now. She did the autopsies for both Paul and Maggie. Two things that she said that I thought were interesting, and I'm curious to know your thoughts on how the defense can come back from this. She said that Paul's hands were down when he was shot, which basically backs up the prosecution's statement that this was not a random person, this wasn't an intruder, there were no defense wounds, and that Maggie was running away when she was shot, but she did not receive a fatal shot at the very beginning. So that person had to try over and over again. What do you think of that testimony?
A lot of times the forensic pathologist will talk about defensive wounds. In other words, right before the injury or the death occurred, a person put their hands up in the defensive posture. Clearly, if you don't put your hands up in defensive posture, you're not trying to defend yourself, because a lot of times you can be injured or killed by surprise. You can be ambushed, even by someone that you know. If you're not expecting it, then logic says, why would you put your hands up? So the fact that the doctors testified, the pathologist testified that he had his hands to his side, that does help the prosecution.
And as I think about this, the possibility of Alec Murdaugh taking the stand, I keep going back to the point that he told a number of people that he didn't go to the kennels that night. Do you think the jury is going to want an answer for that discrepancy?
They're going to want an answer for that discrepancy. And going back to him testifying, you know, for 37 years, Judy, I've been using a rule when it comes to testifying. Number one, I'm not afraid to put him on the stand. But if you're telling the truth, I tell them, think about that hard now, because the rule essentially is this: don't talk and you might walk.
Yeah.
So that's what he really has to think about.
Don't talk and you might walk.
Right.
Okay,
Right.
okay.
If he gets on that witness stand, those prosecutors, they have a lot of experience, and they will do everything they can to impeach his credibility even more because of the things that he may not even be able to explain.
And speaking of Alec Murdaugh's alibi, I want to play a clip of the video that was released today showing him telling Sergeant Daniel Green, one of the first responding officers on the scene, what he was doing the moments before he found that his wife and son were killed.
When was the last time you were here with them or talked to them or anything like that?
It was earlier tonight. I don't know the exact time, but
Okay.
I left. I was probably gone an hour and a half from my mom's, and I saw them about 45 minutes before that.
Okay.
I rode around with Paul for 2 hours this afternoon in the pickup truck.
That's your son, Paul? Okay.
Somebody going to check him?
Yes, sir. They've already checked them.
They did check him?
Yes, sir.
It's official that they're dead?
Yes, sir. That's what it looks like.
I'm sorry.
No. You're fine.
I'm very sorry. Gotta call her.
So when we talk about the possibility of putting Alec Murdaugh on the stand, if you heard him with that timeline in that video, he says that he was gone for an hour and a half at his mom's house. At one point, other testimony said that he was there for 30 or so minutes. And another part, he was so-called sleeping.
And don't forget, at one point he said that he tried to check them. But in this video, he's asking if they're dead.
Yes. So at this point, when you have all these different versions of a timeline, would the defense probably put him up there?
That's a very serious strategic decision that they will have to make.
Yeah.
Again, it's very risky. But the point is, if he gets on that witness stand, he is open to anything the prosecution want to ask him to impeach his credibility. And it may be that some of the things that are not explainable, he's the only person that can explain them. And he may have a difficult time doing that. Now, one thing you got to appreciate is this. He is not the average client. He's very savvy. He's very articulate.
He's an attorney.
He's a trial lawyer. That's right. All right. He's very savvy, very articulate trial lawyer, a lot of experience. So the question is going to be, can he match wits with the prosecution as a witness versus the prosecutor?
Wow.
Obviously, he can. So maybe that's one thing they're weighing. Can this man handle himself on the witness stand? A lot of times you may have a client that simply cannot handle themselves on the witness stand. This guy can do so.
That's the final word for today. Much more of our legal analysis with trial attorney Carl B. Grant throughout the trial every single day.
Yes, Carl, thank you so much for coming on. And of course, we'll see you back tomorrow to see what else develops out of day 17 of the Murdaugh trial.
Thank you for inviting me.
We're going to take a quick break. We'll be right back.